Someone make it make sense.
Probably a couple.
Hello, hello. Can you guys hear me? Let's get some nice music going. Yeah. All right. So, and I've got this new thing here for when we're doing our BK coverage. This is the first. And basically, you know, the filings in this case are insane. By the way, so the plan with this here is, you know, while some people might use a camera and like, you know, the person talking, I guess for me, I'm like, I would rather put together something that you guys can look at and, you know, it's related to the case, because like, you're not going to learn anything from looking at me. So like, and this is going to actually replay over and over. So if you're ever like, oh, I missed a picture. So like that was a historical picture we just saw of the courthouse. So some of this stuff's really cool. I've got a lot of different things on here that it's going to show, but the filings in this case are insane. So initially my plan was there was like 2 filings when I first like created this live stream. And then right before the live stream, I was like, let me just check and like reload and see if there's any more filings. And there's like 8 more filings since then. So there's like a ton. I don't even know that we'll get to it all. But we're going to go through as many as we can. And that's why I was like, you know what? Like, there's so many filings in this case that no one covers them all, you know? So the plan is to just kind of like read through them. Let me see what y'all are saying in the chat. Hello, everybody. I love that you guys are here. So happy to see all my friends. Yay. And you guys all know your commands, hopefully by now. Also, let me put this in the chat for you guys too, for anyone who's new. So here's some pictures too we have of the house, right? There's all kinds of stuff on here. So I'm happy you guys are here. Thank you for being here as always. This is going to be really fun just to go through these. I know Blackwater says, I love that STS showed your link today. I know, that was so sweet. I love that too. Yeah, they've been super supportive and wonderful. And, you know, you guys have seen Spacey's popped in here from time to time. COE's popped in here from time to time. It's awesome. And I love it. You know, to quote Meave Moen, a rising tide lifts all ships, right? So I fully believe in that and always have. And I love it. So, so what was the other thing I was going to say? So yeah, so we have pictures of the house here. Right. Oh, I know what I was going to say. So did any of you guys not see the hearing that happened recently where they had the expert come in and talk about the jury survey, or not? Yeah, the survey for the potential jury. What makes sense now, wifey? Something makes sense. I'm glad something makes sense. So yeah, if any of you guys, so that hearing was insane, and there's other people on Lawtoo that have covered it, but all of these filings are after this hearing, because the first filing we're going to start with is the judge's order to allow the defense surveys to continue, which was filed on April 19th. If you guys didn't see that hearing and you guys want me to cover that, I can. The hearing is insane. It is really informative. You learn a lot, but it's also really fiery. There's a lot of really great, you know, sparring between the attorneys. So what's making sense, you guys? Let me see. Did I miss something? That makes sense. Another thing I will say too, let me just get this out of the way too. So tomorrow we will start our coverage of the Gloria Satterfield. So that's the continuation of like the Murdoch series. You guys already are probably aware of that, but that's starting tomorrow. That's going to be also very insane and really, I'm super excited. That's something that there's been like little to no coverage on, and there's like a huge backstory there, and it's going to be it's going to be really epic. So I'm really excited for that as well. So also, I will say this too, for those of you guys who were here when my brother popped in, and my brother popped in. So right now, spring is like storm paradise for storm chasers. And actually, even for me, like if I just like go on YouTube, it's all over the news. The tornadoes. I don't know if you guys have seen it, but like it's all over the news in like multiple states. They've had tornadoes. My brother's out there right now storm chasing. Don't be surprised if you see him on the news. They might use his footage and credit him, or they might actually, oftentimes they'll actually have him talk about it and they'll actually interview him. Don't be surprised. So just be on the lookout, because this is the time. And this season will go on for like, I don't know, probably another month or two. So he's going to be out in the Midwest pretty much that entire time. And he just follows the tornadoes. And also I created, hopefully it'll work. Let me see if it'll work. A link for anyone who wasn't aware. And this should hopefully share the link to his YouTube channel here, if it works. And then, okay, that didn't, I don't know. Does that work? It doesn't look the way I expected it to, but hopefully it looks to you guys like it normally would when links are shared like in other chats, and that's like a clickable, workable link. I know, where's DSN? We need DSN for sure. Somebody message him on Discord and be like, where you at, yo? We definitely need DSN. I know there were some other people too that were like, seemed like they were going to be popping in. I don't know if, do you guys know, is STS still going with, I was there at the beginning for the show that started at 5, and then I had to start getting all this stuff ready. So I don't know if they're still going. Do you guys, do you know Blackwater if they, or, I mean, that would be long, but I wouldn't be surprised considering the topic. Okay, come back when you can, wifey. Yeah, do y'all know if that is still happening? I mean, it would be long, but so, and in case y'all didn't know, there was some crazy shooting in Charlotte today. Yay, there he is. It worked. Well done. Oh, sorry. Well done, Blackwater. She was willing you here with her mind, and her powers worked. That's awesome, and I love it. I'm so happy you're here. We have that. Hold on. Give me one sec. Sorry, didn't mean to repeat that. So classic. And tomorrow, like I was saying, we will, don't be sorry. We're glad you're back. Tomorrow we will be back to Murdoch land, which is awesome. Also, I know we haven't done Chad yet, but I do have a command for him. I think, hopefully, you have some new commands up in here. There we go. Oh, your fringe. Yeah, is it in that awkward stage where it's a bit short? I know what that's like. I've been there. Let's look at our new. Let's enjoy this for a second. That's for Chad. Very good. Yeah, DSN took the closet portal. Always a good way to go. Always a good way to go. Yeah, it is called bangs, but I know it's also called fringe. I'm familiar. I have years of doing my own hair stuff. So, and I've had bangs many times / fringe. So yeah, so we have our fun music. Okay, so like I was saying, there's like loads of filings. Let's go ahead and get started. Let me see here. So this is going to be fun. This is going to be, oh, you cut it extra crazy. Yeah, we've all been there with the bang. Yeah, that's a tough one. You know, you can always just like in the meantime, like slick it back with like a bandana or a, you know, like a head thing. What do you call it? Like, you know what I mean? Like headbandy thing. When it's that awkward, if it's too short, that's what I would do until it would grow out more. So, okay. So this is going to be fun because this is going to be a bit different because we're going to be going through a lot of legal filings. I'm so excited. I just paused that. Oh, wait, I meant to pause the music. Hold on, pausing the music. All right, there we go. Okay. So this is going to be a bit different because I'm going to be screen sharing and we're going to be going through these legal filings. And we're going to be doing a lot of this too for Gloria Satterfield. So that's exciting. DSN saying hi to Triple R, AKA Triple R Wifey. And for anyone who missed it, I'm going to go ahead and pop it one more time in here for my brother because he's out there following all these tornadoes. And if anyone wants to let me know if that link appears normally in the chat, that would be awesome. Oh, Black Widow says, I see what you look like a hatchet head. I understand. I know what you're saying. Yeah, we will need to develop new inside jokes for this case. I'm sure they will happen. I have no fear for that at all. If anyone can do that with this case, it's us. Okay. So let me see if I can share my screen. It is time. Okay, hold on. So entire screen 2. Okay, this should work. Let's see here. Oh, cool. There's a switch there for system audio. Okay, that's good to know. Learning. Okay. Is it doing anything yet? Oh, hold on. Let me remove the video. Okay. Oh, I have to add it to the stage. I knew that. I remember going through that before. Okay. Can you guys see it? Is it working? I think it's working. Cool. Okay. Awesome. Were you saying works perfectly in reference to the link, or was that for the screen? I think that might have been for the link, but hopefully both are working. Yeah, that's totally fine. Jokes at his expense are welcome. You'll notice that his image did not appear in that opening slideshow. So yeah. But in there were some cool things. We saw there was the old Latah County courthouse from like a billion years ago. There was that cool drawing. It's actually, you can get it on like an art place, and it's like from 1898 of Moscow, Idaho. And there was a picture of Moscow, and like there was just some, some cool stuff there. Hopefully you guys liked that. Okay, so as you can see, all right, we got a lot to go through here. As you can see here, we have, let me make sure. Okay. So here's the date. Hopefully you can see my cursor, this is what's great about the screen sharing, because a lot of times you guys don't know this, but when we're doing the videos, I'm like pointing at things with my mouse, and I know in my mind that you can't see what I'm pointing at, but I still do it. But it's really nice that now you guys can actually see what I'm pointing at, which is nice. So here's the date. So this is how you see, it's official, right? Oh, hold on. I'm on okay, over here, scrolling. So also I hooked up a mouse, for the scroll, like instead of using my touchpad or whatever you call it on the laptop. So the mouse is nice. Okay. So just here, so we can see what we've got. So this was the first thing in the slew of things that came out, right? Again, this is the first filing after that hearing that they had with the expert talking about the defense jury surveys, right? So as per usual, Judge was like, let me think on it. He's not one to make rash decisions. So here's what he said. And you guys may have heard something about this, but we're going to go through it. So order allowing defense surveys to continue. Again, hopefully you guys saw the hearing. If you didn't, again, I can cover it, but it was really interesting. There's a lot of talk about what is public record, right? Because essentially the way the court understands public record is legal filings. But what the expert was saying, which makes sense, right, is the public record in terms of a jury, like a potential jury pool, public record is anything that's out in the public, right? Which could be true or false. So that includes social media. So this is where it gets really interesting. And I really loved the discussion about this. This is like right up my alley, because they got right into the heart of what is public record. And I'm like, I'm so here for this right now. This is my favorite thing. I'm like in heaven, like hearing them go through this and try to figure it out. And I just love it. It's like that case, Nix v. Hedden, where they had to decide if a tomato was a fruit or a vegetable, and went all the way to the Supreme Court. I think I talked about that already before, but anyway, so they had to talk, they were talking about that, and basically had to kind of concede that they understand that public record is, there's going to be a different understanding in terms of how the law, in the legal community, right, versus like out in the public. And then, oh, what else was I going to say about that? Right. And so then there was the other thing, which is like, well, the reason, the way the legal community views it and the court, right, is like any legal filings that they make available to the public, such as what we see here, right? What I'm showing you, these are what they consider public record because it's available to the public, but it's through the court system. So anyway, okay, so hopefully that makes sense. So order, now also I do want to point out, so we've talked a lot about, you know, civil versus criminal trials and plaintiffs and whatnot, right? So I think I've mentioned this before in a different video when we were doing Murdoch, but remember when you see, this is a great way of understanding, right? Because no matter if it's civil or criminal, the trial, there's always a plaintiff and a defendant. But if it's a criminal trial, the state or whatever, you know what I mean? Like the law, the government, they are going to be the plaintiff. Whoever's bringing the criminal charges is the plaintiff because they have a complaint. So if this was a civil trial, it would be a person, right? Or a company, whatever. The railroads, for example. So here it's the state is the plaintiff. So it's sort of, if you can think of it that way, right? Somebody's complaining about something else. And if it happens to be a government body, then it's criminal, right? So, so State of Idaho, plaintiff, Bryan C. Kohberger, defendant. I also think it's interesting how with Chad, they use his middle name, Guy, you know, because these are both out of Idaho, obviously, but with Kohberger, it's his initial. And I don't know if that's the defendant gets to choose or if it's just because of the length or what. Although I wouldn't be surprised if Chad had the option to use G and he wanted to use his middle name, because I feel like he would like that because it's so lame. Like the only thing more lame than Chad is like Chad Guy. So it would make sense that he thinks it's cool. What doesn't make any sense, DSN? Hold on, let me move my mouse to the right thing. Something doesn't make sense. Okay, so hopefully it's not what I was trying to say, because I'm hoping that I'm explaining things to make sense. So let me know if you have a question about something I was saying that doesn't make sense. Okay, so right. So we already know this. Hopefully you guys are aware. You know, on March 22nd, the state filed a sealed motion for, let me do it this way so you can follow along as I'm reading. A sealed motion for the order prohibiting further contact with prospective jurors absent leave of court. The same day, defendant Bryan Kohberger filed an objection to the state's motion with the promise of a forthcoming affidavit and memorandum in support of the objection. The court then entered a temporary order prohibiting both parties, quote, from contacting potential jurors about this case, including via third parties, until further order of the court. And then a hearing was set for April 4th, which they had, and that's the hearing I was saying is super epic. In the interim, the defense filed a memorandum in support of objection to the state's motion for order prohibiting contact with prospective jurors absent leave of court with the declaration of Brian Edelman. That was the fancy expert dude. Attached, and a motion to rescind order for failure to provide due process. On March 29th, 2024, the state filed a declaration in response to defendant's motion to rescind order for failure to provide due process. A reply in support of motion for order prohibiting contact with prospective jurors. So this might seem like, what is all these words? These are all the filings. They just have really long names. So each time you see a really long string of words followed by a comma, that's a previous aforementioned filing, right? Like, for example, this right here where my mouse is, that's the thing we just referred to up here. And an objection to defendant's motion to rescind order for failure to provide due process. Again, they have to use the full name, even though they've already referred to these things already. You know, they're not about saving paper or ink or making things easy, right? But also for clarity, right? They have to use it. So on March 29th, 2024, the defense filed a reply in support of motion to rescind order, blah, blah. They replied. Okay, great. April 4th, okay, the hearing was open to the public, right? Because neither party requested that the hearing be sealed. Now, interesting, because that's a bit of foreshadowing, right? Because this happened on April 19th, which is before the prosecution then filed a motion to have the next hearing be sealed, which is, so again, it's funny because he's actually saying that they didn't request it to be sealed. And then, of course, right at 4 days later, right? Yeah, 4 days later, the state requests the next one be sealed. At that time, the court heard arguments from both parties regarding a survey the defense had conducted in Latah County and wished to conduct in 2 additional counties. The state took issue with 9 questions in the survey. So this is great. Basically, for anyone who missed that hearing, Judge, who wrote this himself, right, is giving you a really good synopsis of what happened. The state took issue with 9 of the questions in the survey, which were read into the record in open court, and argued that asking those specific survey questions to potential jurors violated the court's revised amended non-dissemination order. Specifically, the non-dissemination order prevents the attorneys, in this case, or their agents. So that, in other words, that Bryan Edelman dude would be an agent for the defense, right? From making out-of-court statements which a reasonable person would expect to be disseminated by means of public communication. And here's again where it gets funny, right? The public communication, right? So how are we going to define that? And that relate to the following. 1, the identity or nature of evidence expected to be presented at trial or any sentencing phase of the proceedings. It's important that he mentioned that because since this is a death penalty case, the sentencing phase is going to be a whole separate thing, right? And 2, any information a lawyer knows or reasonably should know is likely to be inadmissible, right? Inadmissible, keyword there, as evidence in trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. The state asserted the questions violated these provisions because the surveyors are agents of the defense. See, that's what I said. Yeah. And the defense bears the responsibility to honor the non-dissemination order. Correct. They both have to follow it. Let me see what y'all are saying in the chat too. Oh, okay. Gotcha. Thank you. Thank you. If you guys I'm going to try to remember to look over here. Let me know if you guys have questions. If you don't understand what's happening in this document or there's words you don't know, I don't want to assume you guys, I don't want to make any assumptions. I'm trying to think of things reasonably should be kind of clarified, using just my teacher senses. But let me know if there's anything in here that is not, well, DSN, it is a first for you if it was a bomb's joke. But yeah, let me know if there is anything you want to have a clarification on or if you have a question or comment, of course. So yes, okay, the defense argued that the questions in the survey were based on information obtained by defense expert Bryan Edelman from reading and watching various news articles and broadcasts from both mainstream media and social media. The defense further argued that the questions did not violate the non-dissemination order because they constituted, quote, here we go, we're getting into the meat of the issue here, information contained in the public record. Oh, this is exactly what I was saying. I love it. Thank you, Judge, for putting it in words so I don't have to fuck it up. The defense argued that the, quote, public record, end quote, encompasses all information in the media for the public's consumption. That's basically what I was saying. But yeah, so that's exactly right. The non-dissemination order expressly, all right, this is important, expressly allows attorneys involved in the case and their agents to make extrajudicial statements, written or oral, concerning information contained in the public record. At the conclusion of the hearing, the court ruled that the defendant's due process rights had not been violated because 1, the order to pause the surveys was entered after the defendant filed an objection to such order, and 2, the order was temporary and defendant was given notice and the opportunity to be heard at the hearing, right? So no due process violations there. This is just due process. They just have to include this, and here's some case law, but for the record, right? But yeah, his due process was not violated is just what that amounts to. The court also kept the temporary order prohibiting contact with potential jurors in place, right, as he was while he made this decision, essentially, right? And instructed defense counsel to consult with Bryan Edelman to determine if there was a way the survey could continue while eliminating the concerning questions to state race. So basically, Judge is like, children, can we just have a compromise in the meantime while I decide what's going to happen? The hearing was scheduled to continue April 10th, 2024. On April 10th, 2024, the parties again reconvened in open court. Again, neither party requested that the hearing be sealed. The questions at issue were again discussed, including the fact that some of the questions on the survey are not rooted in fact or supported by admissible evidence, but are simply rumors in the media and on social media, while other questions were formulated based on the information from the public probable cause affidavit filed by the state. This is the hearing that got extra fucking spicy. It was really good. Because this is when the freaking expert literally pointed at Bill Thompson and was like, you're the one that came out on a news conference or whatever, press conference, and told everyone to go read the probable cause affidavit. She said that, which this is where it gets really interesting again, because, when do you guys remember, this was right after, BK was arrested. Do you guys remember that was the first big press conference where he came out and he was like, this is going to be released, the probable cause affidavit, it's going to be available so you can read it. And he encouraged people to read it. And it's funny because normally that's a good thing, right? Because you don't want people to speculate, please, right? I would rather them have the actual information correct, right? The point of it was so that it would hopefully end or reduce speculation, right? And reduce all the nonsense. But then this Am I here? Okay. I don't know what happened. Hopefully you guys, is everything okay? So DSN is asking a good question here. Did law enforcement release too much info too early? I don't think so. I don't think so. I don't think so at all. And in fact, they've really kept everything really close to the vest, as they say. I think that what he's saying is just that he's pointing, I think the expert was trying to point to the fact that in support of his definition of public record, it's like, even if it's a court filing, right, it still can be part of reaching a greater pool of potential jury pool because he came out in a press conference, right? In other words, okay, let me put it this way. Like the general public, how many of the general public are going onto the Idaho website and looking for court filings? Like your average person is probably not doing that, right? But an average Joe, let's say, could be flipping through channels and come across that press conference, right? Where he is giving information and saying you can read this and that. And so in other words, so the information wasn't too much information. I guess the point was more that it reached a greater number of people because of the press conference, if that makes sense. And it's a way to sort of be like, this is just something we have to accept, because even if you're the government, right, if you're the state, if you're the prosecutor, you can be putting information out there, even if it's the correct information and it's not too much information, but it's reaching more people, if that makes sense. That's kind of what I took out of it. Hi, Super Planner Girl. I'm happy you're here. So yeah. So, and again, I would love, if you guys want to watch that hearing together, I would be happy to cover that, because again, it's just really good. And they go into all of this, but he does say that, like, you know, a lot of the information in the quest that he used for the questions came out in this probable cause affidavit, but that again, I think it's almost sort of like trying to point the finger to like the what is it? The pot calling the kettle black. I think that was his other point too, which is like, well, how can you be mad at us because look at this, you did it yourself, right? I think they were really getting snarky with each other, I felt like, because first of all, what happened was this expert seemed to be kind of offended because he felt like the state was trying to say that he was intentionally poisoning a jury pool or something like that, or it was inferred or implied, and his reputation was on the line. And this dude has like a really solid reputation apparently. And so then I think it was really kind of like, you know, almost like bickering, right? And so then he's like, well, you know, you fucked up too, because you did this press conference, blah, blah. So I think it was also just sort of like that, like just trying to make him look bad kind of thing, if that makes sense. Okay, so then I think I read this right. So the questions at issue were again discussed, including the fact that some of the questions on the survey are not rooted in fact or supported by admissible evidence, but are simply rumors in the media and on social media, while other questions were formulated based on the information from the public PCA filed by the state, which again, I wonder if he's going to bring up that. I wonder if Judge in this is going to if he's going to address that press conference. I wonder, he might. After a lengthy hearing, the parties remained at odds, no surprise there, over whether the 9 questions at issue should be allowed to be asked in surveys conducted by the defense in other counties. The court now orders the following. 1, the public record. Okay, he's defining public record. Thank you. As that term used in the non-dissemination order means the public court record, i.e. information from public hearings and from documents filed in the case that are not sealed. 2, information that formed the basis for 6 of the 9 questions at issue came from the probable cause affidavit. So that was, again, that's referring to, pointed out from that press conference, like I was saying, a document filed in this case that is not sealed. The non-dissemination order expressly allows attorneys involved in this case and their agents, blah, blah. In other words, he's saying that's fine. That's allowed, right? Additionally, one of the questions was not based on admissible or inadmissible evidence, but instead asked about the feelings of members of the Moscow community. Therefore, the defense did not violate the non-dissemination order by asking 7 of the 9 questions. So now we've got 2 questions left that he has to assess as to whether or not they violated the non-dissemination order. As to the remaining 2 questions, there it is. Prior to the hearings, there was not, quote, information contained in the public record, end quote, about these, quote, media items. However, these questions have now been read into the public record, and that was the whole thing too, because they read them into the record. and discussed at length. So that was the funny thing, right? Because it was like by discussing them in a public hearing, now they're part of the public record, right? And discussed at length during the hearings, including the fact that these media items may not be true. So, for example, in case you missed it, the thing about the stalking, right? So, in other words, that is not something that was in the public or the public court record, right? The filings, right? Like as he defined in item number 1 here, that was not put in any document, but now it is technically, because as you guys know, these hearings count, right? When we watch them, we're watching the hearing, but they're all transcribed, right? And they become part of the court record, right? As again, that's the public record as defined by the legal community. So essentially, when they were discussing this question about the quote unquote stalking, because they discussed it in this public hearing on the record, it is now part of the public record, even as defined by the court, if that makes sense. Hopefully that makes sense. So it now is, like, in other words, they like shot themselves in the foot. I think that's how the saying goes. So these questions have now been read in the public record and discussed at length during the hearings, including, right, the media items that may not be true. Because the information is now in the public record, right, the court does not see any benefit in preventing the defense from continuing, right. I mean, this is the fair ruling, from continuing its surveys or requiring that the last 2 questions be eliminated. Again, these questions and media items are now part of the public record. He's right. This is fair. And now, if they didn't want that to be the case, they could have not read them into the record, and then it would be different, right? The non-dissemination order does not prohibit that the attorneys involved in the case or their agents from making extrajudicial statements about information contained in the public record. So yeah, the non-dissemination order also allows extrajudicial statements that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. Any such statement shall be limited to such information as is necessary to mitigate the recent adverse publicity. Defense counsel argued at length that the 2 media items not contained in the public record were the subject of extensive media coverage that was prejudicial to the defendant, and that the survey questions asking potential jurors if they had read, seen, or heard these media items was necessary to support the defendant's motion for the change of venue, right? So what all this is to say, you guys probably already know this, right? But they're trying to prove that they should have a change of venue, right? And so they're trying to show if the potential jury pool has been biased by extensive media coverage. So which is aimed at mitigating the effects of prejudicial pretrial publicity on the defendant's right to a fair trial. 5, the goal of the non-dissemination order is to ensure a fair and impartial jury can be impaneled so the defendant receives a fair trial. If defense counsel believes asking these survey questions, which arguably contain prejudicial information or misinformation, referring to the 2 media questions, right, about the defendant, is more beneficial than harmful, as defendant's expert testified, this court does not at this juncture have sufficient information or evidence to second guess that strategic decision by trial counsel. So do you guys understand what he's talking about there? Like, remember, part of the whole reason this was such a big uproar prior to the April 4th hearing, right? When this first came out, everyone was like, what's going on? Because essentially it was like, look at these questions, right? Everyone read over the questions and it's like, what's going on? And it seemed potentially like there was a strategy maybe by the defense team to kind of, okay, whether it's intentionally or not, the concern, be careful how I say this, whether it was intentional or not, there was concern that the questions themselves would poison a potential jury pool, because if somebody doesn't know about it, right, but then they hear the question being asked, now they've been given that information, right? So that is what he's referring to there, right? So of course the defense is like, well, we have to, if you have any questions about that hearing explains it all. He's like, you have to ask these questions in order to find out what people know, which it makes sense, right? He's like, if you just ask somebody, do they know something general? Have you heard of this? Like, they're going to say no, but then if you give them something specific, then they might realize they did know it. I mean, he did a really good job of explaining it. Yeah, and I agree with what you guys are saying, like that they would afterwards they would look it up. And then they even talked about that. They talked about that in the hearing. And what are you saying not to me? I don't know what you mean here, wifey. And Yeah, I mean, I think who was it? Was it Bill Thompson? Somebody involved in the I don't remember if it was the defense or the prosecution, but somebody said they were like on vacation in Mexico and people in Mexico recognized them and asked them about the case. And so, I mean, that's part of the thing too. Like, I don't know. It's like, they can't move it to another country, but like, I think they would have to move it to another planet to ensure, like, in other words, like, is it even going to help? Right. But that's what they're trying to assess. So, and we know about, we've seen this, like, think about like, we have to remember, compare it to something like OJ, right? Where you have a celebrity. And again, I was really young, so that was before my time. But my thought is this: surely there must be trials that had even more coverage than this, right? Probably. I mean, now the difference now is that information is spread so much more easier compared to like when OJ was having his trial, right? With social media and stuff, like news is just spreading differently. But even still, I think there's got to be more trials that not that it could have happened, right? But if it were possible to survey everybody in the world, right, and get a fair idea or an accurate idea of who's heard of a case, right? I would be surprised if there wasn't a case that actually did have more people that knew about it than this one. And again, just to reiterate, knowing about it I'm correcting myself here, essentially. Knowing about it isn't the problem, right? It's about whether you can be fair or not, right? So it's not a problem just to have heard of it. So I'm just making sure I'm clear on that. But finding out if somebody knows about it, right, would be a good place to start in terms of then seeing, what the deal is. So, okay. So, right. Okay. So number 6, the court's order prohibiting contact with prospective jurors until further order of court is lifted, and the defense may continue its surveys without modification to the survey questions. I think it's fair because at this point, everything's already on the record now. Any extrajudicial statements by any attorneys involved in this case or their agents must continue to comply with the non-discrimination order. What I will say is if they were to like say add more questions, they'd be in big trouble at this point, right? Because he's allowing them to continue. Okay, we got that one done. Next filing. So this one so you can see it says here electronically filed April 23rd. So this is from Bill Thompson. Just a little fun thing for you guys here. This part, when you see this on filings, which you probably are familiar with and seen many times, this is called a caption. And in any court document that's filed by a party, you have to have the caption. And each state is going to have different rules for how it has to follow the certain type of font and size and margins. And there's all these specifications you have to follow, and you have to get it right. Otherwise, bad things happen, and it'll always have the case number, and the case number is going to be the same for everything. So like all throughout, right? This case, even through appeal, this is going to be the same. Or okay, if he gets convicted, right, and going through the appellate. In other words, that's going to be the same. That is the same number. So after 30 years, there's going to be like 50 bazillion court filings with this number, right? Okay, let me see what you guys are saying over here. Okay, you guys good? Everything making sense? Okay, so I also think it's funny because here they say come now instead of comes now. Usually we see comes now, but again, that just varies on the, where you're at here. They all have their own tradition. Okay, so this is the thing you may have heard about, right? This is from the state. The state is filing this, a motion to close the next hearings pursuant to I.C.A.R. 32G. Don't worry, we're going to go over that. And a request for scheduling order. All right, comes now. I added the S. Sorry, I'm just used to that. Come now. This is just weird. The state of Idaho, by and through the Latah County prosecuting attorney. I could read this in a funny voice. I don't know. That might not be appropriate. That just came out of my mouth. So requesting to close the May 14th, 2024 hearing regarding the defendant's 4th motion to compel and any hearing to be set for the defendant's 5th motion to compel. So what are these motion to compels? These motions to compel are getting them to turn over discovery. That's what that's about. So, they have these different hearings, and the hearings have different topics, right? With different purposes and things they're going to do. So these hearings that they're talking about here that they want to close to the public are specific to this. the defendant's fourth and fifth motions to compel. Now, more than likely, if I had to guess, this is going to have to do with the IgG. Oh my God, why am I forgetting the acronym? The DNA stuff, the IgG, oh my God, investigative, IgG, investigative genetic genealogy. That's what it is. The IgG. That's and so okay. I haven't read these yet. Okay, by the way, but if I had to, I'm thinking it through and trying to imagine what's going to be happening here. There could be many reasons why. One of them, because they've talked about it before in previous hearings, is that part of the issue with this, well, there's a number of things. Basically, okay, first of all, to put anyone's mind at ease, in case you haven't heard it, you can hear it now. The IgG was not used to charge him with anything. It's not going to come up at trial. In other words, the state's not entering it as evidence. So the defense has had so far to actually kind of fight to keep this even still being a relevant topic for the court, because of the fact that the state has argued this isn't even relevant because it's not evidence. Like his DNA sample is how they matched him to the knife sheath, right? So it came from his mouth, buccal swab. So they didn't arrest him or use that. Like, you see what I mean? Like, this is not evidence. So, but what the defense has argued is that they're like, well, before we get to that, we have to understand that how they even found him in the first place. So yes, okay, they did use IgG in order to initially, I can't even remember at this point, it's been so long since they first started talking about this, but they used it with the dad, I guess, from when the dad threw out the trash or something. I can't even remember anymore. And it might be discussed further in these filings, but basically, in other words, some people may be confused that this is all these hearings and motions discussing this IgG. Some people might think that they're disputing the DNA evidence that they used to connect him to the knife sheath. And I just want to settle it once and for all. That's not what they're discussing. There's two different things, right? With the DNA. There's the IgG, which was used prior to arresting him and is not evidence, and is not, the prosecution is not entering it as evidence. And that is not his actual DNA, right? By definition, it's familial DNA. Then there's his actual DNA from the buccal swab. That's something completely different. They're not fighting over that right now. They can't, right? That's the thing. They can't really. I mean, they're going to try to cross-examine, I'm sure, at trial, but as we all know, it's really hard for that, right? That's the whole thing. So, okay, so hopefully that makes sense. So my thought is that these motions to compel, because the compel is going to be discovery, and my guess is it has to do with the IgG. So anyway, but my point was this, is that it could be, the part of the reason they might want this sealed is because, as we know, because they've talked about it before, with the IgG, there's people's names, like, of how they got there, right? If they're really trying to follow, how did they find the person related to so-and-so? It's people that are not related at all to the case, right? Like, in other words, like, protect the privacy of people who were used, right? Because their names shouldn't be brought up. They're not part of it. So if that makes sense, right? Because, like, you know how there's some people, it's like they wouldn't ever want to contribute to these databases just because, like, I guess privacy concerns. This would be an example of that. So that could be why they want to have it closed, so that if they are discussing this discovery, it might come up where they are going through this. That's just a thought. Let's see what else it says. This motion is made pursuant to Idaho Court Administrative Rule 32G, and the likelihood that the state and the defense could be prejudiced by discussion or dissemination of information that has been stipulated to be filed under seal. And then they are citing all of these previous motions here. And there's a bunch of them. And then here's the parentheses ends. Okay. There exists a compelling interest at stake to preserve a fair trial, obviously, and no reasonable alternative exists but to conduct a closed hearing. The state further motions the court for a scheduling order for May 3rd for the defendant to file any notice of witnesses, exhibits, expert reports, or other evidence the defendant intends to rely on for the hearings regarding. So this all makes sense to me. This all makes sense. The state, we're going to go through the rule. Okay. Let me back up. they're requesting two things here. The first thing they're requesting is that this hearing on May 14th, they're requesting that hearing be sealed, and they're citing, to back that up, they're citing Rule 32G. We're going to go through that. Don't worry. The second thing they're requesting is a scheduling order for May 3rd. They're not requesting that be sealed or anything. That's going to be open. A scheduling order so the defendant can file any. And so what they're saying here, those are going to be, this makes sense, right? Because if they're going to have this hearing on May 14th, they want the defense prior to that on May 3rd to turn over their notice of witnesses, exhibits, expert reports, or other evidence. So this would be, remember how we've seen this before where they had somebody who was trying to like second guess the IGG stuff, right? From like, this was like a couple months ago, probably. That would be an example. Any of that they're going to use. Again, they haven't stated this. This is just my guess. My intuition is that these motions to compel are regarding the IGG because that's what they've still been fighting about. I think everything else has been turned over. They're still fighting about this IGG. So that would be my thought. Let me see what you guys are saying. Okay, what are y'all? Are you guys having a good time over here? Hopefully everything's making sense. Yeah, it's hard, wifey. Like, I get it. And the thing is, one thing that I can say helps, I think it's helped for me and probably other people, is really this type of stuff, right? Because here's the thing. I think that a lot of times, a lot of the bias happens because there's so much that you don't get. And that's why I wanted to cover these. And the same thing with like Gloria said, there's so much that you don't get the full picture of just by hearing people report on it. They're going to just give you an overview. I mean, how many people, I will be honest, I think outside of like LawTube, which means, these actual attorneys that, on YouTube that are reading it the same way I am, I doubt that any people that are commenting on it have even fully read these documents. They probably are just getting a summary word of mouth like everybody else and making assumptions. I mean, I could be wrong, but I would be surprised if they're reading all of these. Attorneys that are covering it are reading them, and I'm reading them. But in other words, people that are commenting on it, right, on whatever platform, even if they have good intentions, even if it's not some sort of weird, crazy, whatever, they still probably don't have the full picture. And so I think that a really good way to be less biased, in my opinion, and from my own experience, is to really rely on this stuff, because this gives you the full picture that you're not going to hear from just somebody giving a summary or whatever, or an opinion. This is directly happening on what's going on with them. You know what I mean? Like, it's just like with anything else. Like, it's the only way to just get the full picture and to see also the reasonings for why things are being done a certain way. And it's just accurate, right? This is the only way for it to get really accurate. It's literally, it is what it is. So that would be one thing I could say. Let me see what else y'all are saying. And I understand absolutely what you're saying. 100%. Yeah. And the thing is too, let's think about it this way, right? Let's look at trials like Delphi, and like potentially Karen Reed. I mean, I heard the defense's opening statements. They were killer. And yeah, I'm allergic to her face, so I can't really follow it. But I will definitely be more interested once it gets to the defense's case in chief, or maybe when the defense is cross-examining that freaking sergeant dude or whatever, the dude who did all the fucked up shit. The dude, I don't remember his name because I don't follow it, but like they said that this is the dude who like was the lead investigator and like took her cell phone and like looked to see if there was like nude pictures of her. Like, I want to hear that dude be cross-examined. That is, in other words, my point is this, is that there are cases, and I know there's other ones too, right? Where it's like, it's clear that something's fishy and they may not, they may be wrong with the charges, or like with Delphi, right? Is it the right person? It could be they could just have the wrong, or was it just that there was a sloppy investigation, or did they frame somebody? I mean, you never know. But my point is this, is that following the evidence is important, because if you really think about justice for the victims, that means finding the right solution. And EDB was actually talking about this today. Like, justice for the victims means if it wasn't this person, they deserve to know who it was. So justice, you know what I mean? So that's the thing. So really, I think that's the distinction is like, in order to really, if you really want justice, the way to really get there is by following the evidence, because you really can't assume the government is right. You know, you can't, and that's the thing. Yeah, and so Voifi's even saying it here, and I don't know if you said that before I mentioned it. That's funny, but yeah, exactly. And so that's the thing, right? So, and I mean, my question would be this: like, how did you get to that conclusion? Like, you know, I mean, I know why. Like, in other words, as you guys know, I've followed all this, so like I understand. But in other words, was it because you saw the evidence? Was it because you saw like what made that, like, if you could try to summarize, like, what makes that different than other cases? I mean, I know that the reasons to me are obvious, but I think that would be important to articulate too, because there's something that makes that case different for you, right, wifey? If that makes sense. I'm just reading through what you guys are saying. Yeah, I'm allergic to Karen Reed's face. I don't know what's up with her mouth, but I can't, you guys, I have a visceral response. I'm not trying to be mean. I'm not saying it looks a certain way. I'm not saying it looks like anything. It's just when I see it, I'm like, like I have a, I have, I feel like my eyes are being burned out. I don't know. That's all I can say. It's just really hard. It's really hard, and it's very distracting. So like if I'm like, so I haven't followed anything about it, which is actually fine because it gave me a much better, like, also I hate the division it's caused and the fighting and the toxic bullshit. I don't care about any of that. But now that the trial's happening, I think that might change. But because there are actually fascinating legal elements to it, right? Like like from a legal perspective, I don't have any, I don't have any opinion about the case because I haven't been following it. So it actually puts me in a good position to now actually appreciate what's happening legally with it without being biased. I have no bias whatsoever. I don't give a shit, right? But except for justice, right? And so, but from what, like, again, that's why I was like, well, let me listen to the opening statements. And from what I heard, it actually, there's a lot of really fascinating things about it. I think what just the problem is for everybody else that was following it prior, you know, things just got really out of hand and, you know, heated and whatever, to where some of that might actually have gotten lost in the discussion. I mean, I don't know. I don't know because I don't involve myself in things like that that are toxic. So, but if I listen to it, right? Like that's what I found. Like earlier today, I was running some errands. I was listening to it, and it was fine because I couldn't see her face. Um, so okay, so Rifey's answering my question. The reason I think he's innocent is because his arrest from the start. Yeah, I agree. I mean, I totally agree. I hope. I mean, it was it. I remember, and I know you and I've talked about this, Wifey, but the day that they arrested him, and I was like, I think that there was a collective response. That's what I felt like when they first put that up, and I came on the news or whatever. There was like a collective, like, huh? Like it was awkward. It was awkward for even the news people and shit. Um, Yeah, and I mean, again, say no to toxicity. And the thing about the toxicity, I think it's in the chats, right? So for me, I think that like the way that I can actually appreciate what's going on legally in terms of this case is to not watch it and to not be in the chats. I mean, it's just clear to me that's not a place for me. I wouldn't even be able to contribute anyway because I'm not going to fight with people, and I don't. Again, I'm not privy to all the shit, right? But like for me, and actually EDB is covering it gavel to gavel, and you know she watches it and gives commentary, and she actually did the same thing. She was like, I'm going to cover this trial gavel to gavel, but I'm going to make sure I go into it knowing nothing about it, like the jury. And that's what she did. She knows nothing about it, no backstory, whatever. And so she's going into it completely blind and hearing the evidence as the jury is hearing it. Um, and that's kind of the same case for me. And she also said that, like, you know, Nightbot and the mods have just like completely stepped up their game so that if people are being, bullshitty in the chat, they're just going to out. Bye. She was like, there's other places you can go fight. Like that's not going to happen here. So, but what's great is like with that, she's just assessing everything the way that I'm talking about it, or, would hope to, which is just, there isn't any opinions or bias. It's just assessing the legal argument and stuff and the evidence. And so, that for me, again, so my point is like, yeah, if I'm going to be following that trial at all, it'll be listening to it. And I have no reason to be in the chat for that at all. So, because I think that if you remove those two elements, at least for me, my personal opinion, if you remove those two elements, then you could actually benefit from it, from the trial, I think. So, yeah, so there was just, so wifey's saying, like, again, the evidence was sketchy. I mean, yeah, it was just sketchy. So yeah. So, and from what I heard in the defense's opening today with Karen Reed, yeah, it's a lot of sketch too. It really is a lot of sketch. So yeah. Okay, so let's keep going here. So this, I think, is the end of this anyway. So, right, the state requests that the court afford the state an opportunity to respond to those initial disclosures and file their shit. Yeah. So, okay. All right. Yeah, we're good to go on this. All right, cool. So, and then this just certifies that they deliver it with legal documents. You have to have this. Oh, but we need to look at the rule. Okay, right. We need to look at the rule. So they're citing this rule, I.C.A.R. 32G. That's the Idaho Court Administration Rules. That's what they're citing as a rule to close or seal that, close the hearing. So let's pull up that rule, and I have it ready to go. Okay, here it is. So this is Rule 32. Here's subsection G, as you can see here with my cursor. Court records exempt from disclosure. Except as provided in paragraph H of this rule, court records specified as below are exempt from disclosure. Okay. Documents and records to which access is otherwise restricted. Pretrial risk assessments. Not all this is going to apply, but let's just see. Affidavits or sworn testimony and records of proceedings in support. I wonder if this is what this is. Remember what I was saying? See, okay. Remember what I was saying? I was saying if this is about the IGG, which it probably is, remember what I was saying? The difference is that they used it. They didn't use it to arrest him, but they used it for like the search warrants and stuff, right? And to find him. So that would make sense. They want this they want the IGG thing closed. And that would make sense because this would be one reason that they could, again, citing Rule 32G, this would be a legitimate reason because they used the IGG for that. That would make sense. It sucks if it is closed because then we may not get the answer, but I'd be curious if we ever find out, yeah, it was the subsection 3, because that would be my guess. And it'd be really funny if I'm actually right about that. Unreturned search warrants, unreturned arrest warrants. And then they're defining arrest warrant, bench warrant, but I don't think that's relevant here. Unless otherwise ordered, blah, 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 except as provided. Every rule has stuff like this where it's like all the exceptions, but that's not really relevant here. Except as provided here, blah, blah. Juvenile court records, not relevant here. Also, more juvenile shit, not relevant. Hospitalizations, not relevant. Yeah, so look, if you guys can see this stuff that you can see is like not relevant. Abortion, nope, not relevant. This could be documents filed or lodged with the court in camera. Potentially that could be relevant. None of this would be relevant. This could this could be relevant too. Remember, like I was saying, it could be because there's a list of the names that were used for the IGG, and these are just random people that deserve to have their information protected. That could be part of it, right? Because it says a list of personal data identifiers if the document is unredacted, which again, considering the motion to compel and the discovery, the defense would be seeking unredacted copies. And that would meet the requirements for this rule. So that makes sense again, like because I was already saying that one. Child custody not relevant. None of that. I doubt that's relevant. I mean, it could be, probably not. Not that. I don't think that is. Yeah, I think it's going to be one of those main two, which is, let's see how many. Yeah, that's the end of it. So 29 is the last one. So I would say the main two I think are relevant here would be this this one, the section 18, and then 15. Again, let's see if we ever find out. You're thinking here, these are my guesses. See if they ever say what they're basing it on. And then it was this one, number 3. So we'll see. Okay, so that's the end of that. Next, yay, another one done. Bum, bum. Another filing done. Okay, yes. Yeah. Yeah, I mean, and I think that, I think that that's in a way a good thing too. I mean, okay. Like, I think if you're going to be assessing things from an unbiased standpoint and assessing the credibility of the evidence and the legal argument and stuff like that, leaving emotion out of it is, you guys have heard this from attorneys, I'm sure too. Like, it's kind of an important part of it. And then dealing with like the emotions, like after the fact, type of thing. So yes. Okay, so now look at all these. There might be even more tabs. This may not be all of them. These were all filed on the April 26th, I believe. So like they filed, like a million things came through that day. It's insane. All right, so now we're going to hear from Ann Taylor. Okay, what's she asking for here? There it is. Look. There it is. There it is. I called it. There it is. Okay, so yes, just as of course. Yep. Hopefully this is making sense, because to me it is anyway. Because again, I didn't read. It's not humanly possible. I didn't read all these ahead of time, right? So we're going through them together. So that's I'm pleasantly surprised that I was on the right track with that. So she says comes now. Look at that. Look at that. Comes now. I'm glad she asked that there. Bryan C. Kohberger, by and through his attorney's of record. Oh my God. And hereby moves this court to allow defense investigators to review IgG materials. This motion is made. So again, they've been talking about this forever now, but this was just filed. So this motion is made to protect Mr. Kohberger's state and federal blah all's rights. I know, you know what I mean. You guys can read it. I need to drink some water, actually. I'm like losing my voice. Okay, the court previously entered an order allowing specific experts access to review the protected IgG materials. And I think that might have been the hearing that we heard. At the time of that order, the defense team requested that its investigators also be allowed to review. Okay, right. I remember this. I remember them arguing about this. So, right, the court, okay, so let me say, so again, and I remember this. This is what I was saying. The point of this specific thing she's saying here was because they wanted to protect the identities, again, of the random people that are just, that they use, that are just on the internet database or whatever it is, random people, protect their identity. And that was a big point of contention, like I was saying. So what the last time they talked about this, the court had said that their specific experts could review it, but that was it, right? So that's what she's saying. At the time of the order, the defense team requested that its investigators, and then I think he said, right, the court said no, right? The court denied it. Yeah. So they also had these, so they had the defense team says, we got these two groups of people. We got these experts, and then we've got investigators. And we want them all to be able to review it. And they said, well, because of people's privacy, we're going to allow the experts, but not the investigators. Okay. So the court denied defense investigator access, but did indicate it would be willing to reconsider it. I remember that. So they're like, are you going to reconsider it? Wink, wink, nudge, nudge, judge, judge. That's funny. That was not on purpose. The Constitution guarantees criminal defendants a meaningful opportunity. Okay, yes, we all know this. We know the rights. Mr. Kohberger is requesting that the court reconsider its decision and allow the defense team investigators to review the protected IGG. A hearing on this matter is requested to explain why the current order. So they want to have a hearing so they can explain why the investigator should be allowed so that judge can reconsider. The hearing does not need to be sealed and should take 15 minutes. Oh, cool. That's short and sweet. Look at that. That's it. Okay. All right. I think that's fair. I hope he grants it because I want to hear what they're going to say, right? Every time they grant one of these, you get to hear more shit, right? All right. That one's done. Next up. Again, on the 26th filed here. Okay, this is also for the defense motion as well. Motion to unseal parts of the IG. So that previous one we just did was to talk about it, a hearing. Now is a motion to unseal parts of the materials. Interesting. All right, let's see what they say. Comes now, blah, blah. Hereby moves this court to unseal the IGG materials signed on 12/29/23, except for the individuals on the family tree or found. Okay, that's the people I was talking about. On the grounds that this information should be made public. Okay, I see. I was confused by her wording. I thought she was saying that the family tree shit should be made public, but she's not. She's saying that everything else should be public and does not meet the requirements for sealing. And I.C.A.R. 32. Oh, that's the same rule. Huh. So remember, we just went over Rule 32G. So 32 subsection G, she's not being specific, but she's just saying the entire Rule 32. It's interesting. I don't know why she's not being more specific. But yeah, so we know that rule, kind of. We know parts of it. The court previously entered an order allowing specific members of the defense team, right? We just heard about this, including specific experts, to review it. The court has indicated during hearings, right? I said all this. I was right. Yeah. The court has indicated during hearings its concern was the privacy of individuals on the family tree, like I was saying. So the defense shares that concern, takes no issue with it. So what they're saying is, can you release all of the information apart from the family tree people? That's what she's asking for. The defense does object to the sealing of the rest of the information that has been disclosed. There's simply no legitimate reason that the way the IGG procedures in this case took place should be shielded from the public. The court has provided no authority. Authority means case law or a rule, right? Like a state or federal rule. Authority. That's what that is. Not like, your boss, right? I've seen Lorna. I've seen her. Oh, you guys are quoting songs. I love that. Thought that I heard you laughing. Thought that I heard you sing me in the corner. Oh, yeah. By the way, Tori Amos does a great cover of that song. Oh, yeah. You have to do something. That's right. You do. I know. So we're learning. Are we all learning? Yay. She's referring to Lorna McKenzie. I'm sure you've seen her. Yeah. Are we learning and having fun? Good. Yeah. Every single thing. It's a lot, right? It's a lot. Yeah. Lorna McKenzie. Yes. But she spells it this way. I saw her recently, but yeah, she's not been around as much for sure. I can't remember. Where did I see her? It was an STS. I don't remember what it was though. Yeah, every single thing is a filing. I know it's a lot. All right. So yeah, so I was going over authority. Correct. All right. Yes. Most materials have been sealed in this case to protect the right to a fair trial. There's simply nothing unfairly prejudicial about the way in which the IGG was carried about the state and its associates in this case. In point of fact, the way in which IGG occurred in this case has been made public in other cases. Okay, so now she's citing some case law. Oh, and look, the Golden State Killer. So when you see the way you can interpret these, I can explain this. Depending on how you see these citations, you can figure out if it's a state or federal court. So here, this is obviously it says Court of Appeals, but it's not always going to say that. It just depends on what the thing is. But this would be if it's a federal Court of Appeals, you're going to see circuit in the citation, just so you guys know. If you don't, so you see here, it says P.3D. The P stands for Pacific. This is what do they call it? Reporter. Like, you guys know, like, you got your court reporters, like, people. There's court reporters, and this goes back to the olden days because everything had to be written down in writing, and it actually still is, believe it or not. Law is very old school. And so they've had to keep track of which thing is in what, the way you find it. So they do it by region and then by volume. And so P is Pacific. And that makes sense, right? Because it's Washington. So it's like the third volume or whatever. And then that would be like where you can find it, like the chapters and pages and whatnot. So State v. Hartman, and then Washington Court of Appeals 2023. That's a semicolon because now she's citing something else. This would be called, this is from the Washington Post. So this isn't like case law. This is like not something you don't always want to be using this as your, again, we talked about authority. You don't want to really be using this. This would be like your, what's the word again? Hold on. Secondary authority. Secondary authority would be something that's not from the court record. Primary authority would be court record, court shit, so case law or rules, right? Or statutes. So this would be secondary authority as in it's some sort of an article from the Washington Post. The only reason you would use this is because there's not that much case law. And that makes sense, right? Because IGG is recent. This is actually, I was going through it in my brain. Like, this is a recent thing. So it actually makes sense that there's not that much case law discussing making the information public minus the people in the family tree. Now, you might be thinking, why do they even need to make this argument? Like you might be thinking, why is it such a big deal? Like, why can't, like, it makes sense. Fine. Just like keep the people's names secret. That's fair. Release the other shit. Like, why do you need, because this is how it works in law. You cannot request anything or say anything without citing your source, your reasoning, right? Your authority. You have to. So you can't just say stuff. So, even if it's something simple or rational or logical or whatever, even if everyone's in agreement, you have to cite stuff. So because IGG is so recent, at first I was like, oh, what? Did she not do enough research? And then I was like, no, wait, hold on. IGG is recent. So this makes sense that there wouldn't be that much, because otherwise you would want to use more primary sources. Like, you want to use more case law versus she's got one citation here for case law and then this secondary source again, because it's an article. And then I love it when they include the link. Can we actually open this up? Let's see. Can we? I don't know. I'm just seeing if this is going to let me open this link. Can you guys see it? I'm shocked that it's letting me read this because, you always get the paywalls and stuff. And I've maxed out on everything researching Murdoch. So I don't know how it's letting me open this, but it did. Wow, that's amazing. So, so I'm able to open this. That's amazing. Okay, so let's see. So what we're looking for, we all know about this case, right? Probably. But what we're looking for is releasing information to the public regarding the IGG. That's what we're looking for. Now, hold on. Let me just see. Did she actually give us anything specific in here? Let's just see. Maybe she tells us what to look for. Aspects of the IGG investigation in this case have already been leaked. Sorry. Interesting. Look at that. I want to read that too. So let's see. She doesn't actually tell us what we're looking for here. Okay, well, let's just see. Oh, it opened it in Firefox. Okay, anyway. Let's see. Okay, they tracked their suspect through his family tree. I mean, yeah. We're looking for something to support her argument that they should release. I'm just reminding everybody that they should release all the information apart from the family tree. I'm just go scrolling through it to see. I mean, I'm not okay. Put yourself in judge seat for a second here, guys. Think about this. Imagine if you're, okay, I don't know, this bothers me. Imagine if you're a judge, and and you're going through this and you get this link, like exactly what happened to us. And then you click on it, and then you're just like given this really long article and not even told where to look or like a paragraph or a synopsis. Does she expect him to read all of that? That's not reasonable. That's really kind of, in my opinion, in a way, kind of like, I don't know. It's just, I mean, he would have to read it because she's citing it. She's using it as secondary authority. Anyway, I don't know. I am interested to see what this is, though. Let me see. Can I? Oops. All right, let's see what this is. Cool. Sorry, guys. By the way, Adblocker Plus is awesome and it's free. Oh my God. Fine. Cookies, whatever. Oh my God, you guys. I can't stand ads. So they said they already leaked some of the IgG. This is so distracting with these ads. I can't even do it. And does she expect him to scroll through all this? I'm just not gonna read all this. I can do this another time. I mean, honestly, it doesn't look like these are that great. So, all right, let's keep going. What do you guys think? Oh, Jess. Wait, what's happening? Jess is here. Jessica M72. Oh, okay. I see. Yeah. Yeah. The thing, it's like, so you have to be subscribed for 5 minutes or whatever. Yeah. The YouTube thing. Okay. Well, if you can hear me, Jess M72, I'm happy that you are here. Okay. So, all right. So those links were pretty much useless, in my opinion. All right. But more importantly, I think that's not fair to expect Judge just sit there and read all that and have to turn off his ad blocker and then be bombarded with ads. Like, he deserves better. This court's order is being abused by the state. Ooh, that's some fighting words. And the FBI. Oh, right. Because they're like trying to act like the FBI was being shady. I remember. To hide how IgG was used in this case because what the FBI did violated its own rules. Right. Do you guys remember that from like a long ass time ago? They talked about this in the hearing. Violated its own rules and the rights of privacy genetic. Right. That was back when dude, they've really been on a long road with this IgG. Their first thing about it that they were all up in a ruckus about was saying their panties were in a wad, so to speak. They were saying that the FBI violated the privacy rules of the genetic companies. Now, I can tell you this for a fact because I've done this. Let me just say. So I submitted my DNA through, it was a site called MyHeritage. It's like, I think it's called MyHeritage. It's like one of the DNA people, but like it was just way more better price than some of the other big ones. And I did it so I could determine my, ancestry, like culturally. Like I wasn't looking for a family tree. I was just looking because what happened was my brother, this was a long time ago. Well, I don't know, like maybe a year ago or so. My brother texted me out of the blue. It was like, hey, I just took a DNA test and turns out I'm like 11% Russian or something like that. And I was like, I thought he was fucking with me. And I was like, what? Because you guys know how I am about Russian stuff. And like, I thought he was like fucking with me. And then he was like, no, I just got a test back, blah, blah. And then we were talking about it. And he said that with siblings, it can actually vary. He was like, so you could be more or you could be less. And I was like, holy shit, I'm taking a test. So that's why I did it. And then I got my thingy back. And it was actually like 20% was like Russian or Eastern European. And I was like, this explains everything. And so anyway, but I saw the thing where you can opt in or out. And here's what I will say. It makes you go through a million fucking disclaimers. Are you sure you want to sign it? I mean, they don't make it easy to just, you can't skip over it. Like literally, you have to actually really want, at least with this website, you have to really want to allow them to use your whatever it is, your DNA or your ancestry. You have to really want them. Like they don't make it easy to opt in. It's like you're automatically opted out, but if you want to opt in, it takes like an extra 20 minutes and you have to really like, which is great. That's how it should be. But I can say, because I've done it, that I know what that's like. And I opted in, but the thing is that these different companies have different rules. And I remember that was part of the with this discussion with them. I'm so glad you're here, Jessica M72. Yay! Shout out to you, Jessica M72. Here's a little song for you. Also, hold on, let me put up my thingy bar. Bloop, 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 bloop. Where is it? Banners. Shout out to all my SDS peeps. Hashtag SDS Gang Gang. So yes. So they were saying I remember when this came up because I was like, oh my God, it felt like they were kind of grasping at straws. But this was their first complaint over the IGG stuff, right? Was that the FBI violated its own rules because of the privacy. But the companies all have their own different policies, and that's not regular. Okay, and this is a whole other conversation, but it's not regulated by the government, right? Each company is a private company that has their own rules about how they're going to deal with the privacy issue and all that stuff. And this is going to be probably what ends up happening in further discussions down the road with all this stuff, right? Is does the government need to get involved because of the fact that it can be used, anyway, it's a whole thing, right? So, but I remember thinking this was kind of a silly argument because right now it's up to the companies. But that's what they're saying. They're saying the FBI violated its own rules and because of the blah, blah, blah. Genealogy companies. Not only is there no authority to protect the FBI, here authority does not mean case law, by the way. I think they mean a higher up. They actually mean like a boss in this case. Not only is there no authority to protect the FBI and the state in this matter, this refusal to permit Mr. Kohberger to expose this to the public is a clear violation of his right to a public trial. Do you guys feel like that's a stretch? Because I don't. Well, okay. I think it's fair if some fuckery happened. I don't think there was, in my opinion, but if some fuckery did happen, he has the right to expose it to the public, right? Like that, like we're going to see this with the Karen Reed trial, right? And it's going to be the same with all the other ones. Like if there's fuckery, that's going to come up in trial. But I don't see how that's a right to a public trial. But, if we wanted to fully understand that, we would have to look up this case law. Oh, well, here it says, sealing of motion to suppress to protect privacy of witnesses was, well, good, she's giving us a synopsis, was error requiring remand for a new public hearing. Okay, let me read that again. Sealing of motion to suppress. Oh, okay, I see. Okay, all right. So here she's saying, so this person got a new hearing, whoever, Waller or something. Oh, Waller sued Georgia. Okay. Because like, by the way, let me actually read, let me explain this citation here because this is a different one. Whenever you see US like that in all caps, that means this is a Supreme Court case law citing. I mean, citing as in CIT, not SIGHT. This is case law from the Supreme Court. When you see, again, remember, whatever name is first is the plaintiff, which can be the government or not, depending on if it's criminal or civil. And the second one is the defendant. So, and just to clarify, you might be saying, well, what if it's like an appeal? If it's an appeal, like let's say criminal appeal, the names are never reversed. It's always going to be whatever the government entity is would be first as the plaintiff and the defendant's always second. So here, again, so you might think, oh, well, maybe it's because it's an appeal because Georgia's a state. No, it's not. Because this is a person's name and that's a state, this is the person suing the state. And it went all the way to the Supreme Court in 1984. Sealing of motion to suppress to protect privacy of witnesses, and I guess that would be akin to the family tree in this IGG situation, was error for requiring remand for a new public hearing. Okay, now she's got some more case law. Idaho. When you're citing case law, you want to always start with the primary authority typically. So that would be Supreme Court. And then after that, you want to go with your state. A hearing on this matter is requested if necessary. The hearing does not need to be sealed. It's interesting. So far of all the filings we've read, everything from the defense has said hearing does not need to be sealed. They want it all out in the open. The previous one, she said it was a hearing, it would be 15 minutes. This one, she's saying, this is actually important. I hope you guys are like, I'm not saying that you guys aren't listening, but like, I'm just talking and talking and talking. So I wouldn't blame you if you weren't, if you're just chatting, because I'm not able to read the chat and this at the same time. Obviously I would need another set of eyeballs, but here's what I'm saying. I'm saying that this is an interesting thing to think about, that we've read a lot of filings so far today, and so far everything from the defense is saying the hearing does not need to be sealed. I appreciate that about Ann Taylor because I think it's important. I think it's important for a lot of reasons. I'm sure you guys know those. It's discussed at length. I don't think I need to explain it, but not that everything. I'm not saying, okay, I understand that there's good reasons for things to be sealed, right? But I just appreciate that even though she could make those requests, she's not, right? And then I also appreciate that she says they're going to be brief. Last one was 15. This one's going to be 30 minutes. So Kootenai, Joe. Wait, what's that? What song is that? Oh, it's Cotton Eye. That makes sense. That's why my brain went there. Okay, what just happened? Squirrel things happened. Do you guys know the song Cotton Eye Joe? All I know is, like, I didn't even know I knew that song till now, but I guess I do. Like something Cotton Eye Joe. So I was saying Kootenai, and then I started singing, and I was like, what am I doing? Now I've just figured it out, because Kootenai sounds like Cotton Eye. So you could do Kootenai, you could do Cotton Eye Joe, and you could sing it about this county in Idaho if you so felt so inclined. For the court filings and stay for the insanity. That should be my slogan for you guys. Yes, thank you, wifey. Where did you come from? Where did you go? Where did you come from, Kootenai Joe? Well, you know what, DSN, if you're still here, this could be the first inside joke of many to come, I'm sure, regarding Idaho, and this would be a good one. No one else is going to know what the fuck we're talking about. I hope DSN is still here. We have a joke, Kootenai Joe. No one will know what we're talking about, but we have a joke. Oh, is it? That doesn't bother me. That's fine. Pretty funny. I mean, well, maybe if that's something we're thinking about, it's, who knows? I mean, I guess, could BK have one? I don't know that he's ever been touched by a woman, so probably not. Oh, good. DSN is still here. Yay. Okay, so is that the end of this one? It looks like it. Sweet. Did-a-dum. Okay, here's what I have to remember. Is the drum on the backbeat or on the downbeat? Bum, bum. Actually, it's on the backbeat. Okay, so it would be like the bass is on the downbeat and the drum is on the backbeat. So but a bum. Hold on, let me just, bum, 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 bum. Actually, it's in two. So bum, bum, bum. Another one bites the dust. Bum, bum, bum. Another one bites the dust, and another one. Okay, you guys know the song. All right. So, all right. Next up, like I said, there's a slew of them. That's why I checked it. That's a funny thing. I will say again, I learned that from EDB. Whenever she would be going over like a case and reading the court filings, she would start the stream and then she'd be like, oh, I wonder if there's any more filings. And she would like refresh the tab. And she's like, oh, look, there are. So that's why right before the stream, I was like, oh, let me do that. Sure enough, there's like 10 more filings since I last checked with this case. Isn't that insane? All right. So what's happening now? Objection. So this is another filing from the defense. Wow, they were busy. My God. You know what? Can you guys appreciate? I know Wifey was saying, wow, they have to make a different filing for everything. Yeah. There's more. This isn't even all of them. Like, can you guys appreciate when they're saying they're busy? And the filings is just the legality of putting it in writing. It's like, that's not even the really hard work or the time. Can you guys appreciate it a little bit? Like, this is another defense filing. So, all right, objection to the state's. Okay. Oh, okay. In case you were like, hang on, I don't want that hearing to be closed. And just to refresh everyone's memory, because we've talked about a lot of different shit today. The first filing we read was the judge's ruling on the jury shit, right? Okay. But the second thing, and I've been closing out of the tab so I don't get myself confused. But the second thing was the state filing on the 23rd of this month, the state making a motion to close that hearing. And what was the hearing? The hearing I speculated on was going to be about the IGG, and turns out that's what it's about. Now, again, I want things to be open so we can see them, right? And I think it's also, there's plenty of reasons for that. As we've said, it's public and all that, right? But okay, if the defense didn't object, it would probably be, so here we can appreciate it, right? If the defense didn't object, it probably would be closed No one's objecting to it, right? But guess what? The defense is objecting to it. So far, the defense has any hearing that they've requested it to be open. And now they're objecting to the state wanting that hearing to be closed. This is interesting because to me, again, this is where we can take the defendant out of it, right? Take the defendant out of it, take all the heaviness and the emotion out of it. We're assessing these legal filings. What are we learning? We've learned a lot, I feel like. But one thing, what I'm seeing from this stuff is hopefully you guys can understand what I'm saying here. Can you get a feel for the, what's the right way to put this? The approach or the mindset of like the prosecution and the defense. Like essentially what I'm saying is through these filings, what I'm seeing is a trend, right? That the defense wants everything open and all the hearings open. And I appreciate that. They want transparency. I appreciate that. And so far, only the prosecution wanted a hearing to be closed. So, yeah. So do you guys see what I'm saying though? Like, I appreciate that. Like the defense wants everything open and transparent. Okay. So we can appreciate that, right? Comes now, Bryan, blah, blah, attorneys, blah, blah. And here every time it's going to be something different. It's just whatever I make up on the fly. Hereby objects to the state's motion to close the hearing to compel on May 14th. So this is great, right? Because again, if they didn't object, it would probably be closed. I hope it's not closed. So thank you. Thank you, defense. The grounds are that Mr. Kohberger has a constitutional right to a fair and public trial. No reason exists to prevent him from a public pretrial proceeding. So here's what's going to be funny. What will be funny, well, funny is not the right word, ironic, is if in a later filing at any time, the defense then does want something, a hearing to be closed, right? Because look at, here it is, like, right, if that happens, that will be discussed, and we'll see it in the filings. We'll see it in the filings from the prosecution. That's how this stuff works. So right now, they're saying he has a constitutional right to a fair and public trial. They're saying fairness and access should be, blah, blah, like, don't close the hearings. So I hope that this is the standpoint they maintain throughout all this, right? But it will be interesting if then they change their minds when some certain topic comes up, right? Okay, so yeah, the state has made no showing that the hearing should be closed under I.A.R. 32. Now they're referring to Rule 32G, which we went through. They're saying the state has made no showing. Well, they cited the rule. There's simply no legitimate reason that a motion to compel discovery should be shielded. Already my mind's going here. My mind's going to this. My mind is saying this. They gave the rule, and I'm like, but okay, hold on. This is how the law works, right? It's like you have to be able to see both sides. And I'm as I read these, that's what my brain's doing. My brain has read this, and it's like the state made no showing but I'm like, well, they cited the rule, and they cited specifically 32G. And then I'm thinking to myself, well, she's also right in the sense that they did not say which part. Remember how we went through that whole thing, and I was like, look at all this, none of this is relevant. And then I was like, maybe these 3 things are relevant. That's a legitimate point. They didn't actually specifically go into what part of 32G was relevant, because most of that was not relevant. Like BK did not have an abortion, right? That was one of the things on there. So, but however, again, going back and forth in my mind, the state said, we would like to have a hearing so we can tell you why it's relevant. So is this making sense? Like you can see how the back and forth happens. Because they asked to have a hearing so they could explain it further. So you see why a judge is needed? Nothing would ever get done. It would just go back and forth to infinity and beyond if you didn't have a judge. Children, stop fighting, right? There's simply no legitimate reason that a motion to compel discovery should be shielded from the public. The process of sealing is being abused. I love it when they get dramatic. This is mild compared to what we will be seeing when we do Gloria Satterfield documents. Just wait. Process of sealing is being abused by the state and its law enforcement agents, including the FBI. Oh, here we go with the FBI again. To hide how discovery is being withheld in this case. I think this is being a bit dramatic, in my opinion. Testimony, and argument on information sought by Mr. Kohberger does not meet the narrow scope of what the state can shield from the public view. And there's that same rule. They're both using this rule to support themselves at different things, which is interesting. Not only is there no authority to protect the FBI, other law enforcement agents and the state in this matter, there's this request to deny Mr. Kohberger an open hearing is a clear violation of his right to public trial. And here's the same. We already saw these in a different filing, didn't we? We did, because we talked about this, Supreme Court. Interesting. Okay. The state has failed to provide all the requested items that were asked for in the defense's supplemental request for discovery to support the charges. So remember what I said? Remember what I said about the IGG? Remember, I said the IGG was like, is not going to be used in trial. It's about like how they found him in the first place. And she's, like I said, remember, I'm like, she's still going after how did they get to him? How did they charge him? That's all this, that's exactly what she's saying here. They're still fighting over that. How did they find him? How did they have the right for the search warrant? How did they get, charge him before they even like did all the rest? Thus, the defense has had to file its fourth and fifth motions to compel. It is not lost on Mr. Kohberger that the state is asking for a scheduling order. Right. This is like what we went through this. The state is like, well, we want to have your information ahead of time. Yeah. The defense to be used in support, blah, blah. We went through that. All right. However, Mr. Kohberger suggests a dual deadline. Okay, that's fair. All right. So what's happening here? All right. What's happening is this. The state, remember when that same filing where they said, and I remember I was like, it's two things they want. First thing they want is they want the hearing on the discovery shit regarding IGG to be closed. And the second thing they want is a scheduling order where the defense has to turn over their information regarding the IGG by a certain time, right? That's what she's referring to here. So Mr. Kohberger wants the same thing, and that is fair. That the defense, that's only fair, right? That the defense says the prosecution have to also file the same shit. Yeah, that's fair. That'll be approved. That's a no-brainer. Response disclosures by both parties should be due May 10th. And that hearing is going to be May 14th. Remember? Now, we haven't gotten to it yet. I don't know. We might see it. We don't know yet if that hearing is going to be closed or not yet because the prosecution wanted it to be closed and the defense objected. Let's see what happens. Kootenai Joe. All right. Look, guys, we only have 2 left. I didn't even know if we would get through these. This is a miracle. I am so proud of us. Yay, team. Oh, I don't know what you're referring to, but thank you, wifey. I'm glad I made a good point. That's always good when that happens. All right. So look, this is about the hearing. I'm not going to click on it because I want us to be surprised because I put these in order that they were submitted and filed and stuff. And this was the most recent one. I'm not going to click on it, but the one about the hearing, I don't know which hearing. This may not be the information on if it's going to be sealed or not. I don't know yet because there's 2 hearings, but we'll see. But that was the most recent filing. That's why we're doing it last because we're going in chronological order. So, oh, look at these. This is about the alibi. You guys, no one's talked about this because these were just filed. I've not heard anything about this. And that's the thing that I was like realizing. I was like, there's so many filings in this case that happen all the time. And a lot of the time on LawTube, for obvious reasons, they're all attorneys, they may not get to them until whenever, but I potentially can pop right on and cover them. So you guys can get the information sooner and we can talk about it sooner. So I have not heard a dang thing about this, but this is in regards to the alibi. What's it going to say? All right. So this is the prosecution. All right. You guys remember the whole thing about the alibi, the stargazing and whatnot? This is the most recent thing that's happened about this that I've not heard about yet because it was just filed. So this is their response. What's happening now? All right. Comes now. Comes. Oh, they used the S this time. So I wonder if it was a typo that other time when they said come now. That's interesting. Comes now. The state of Idaho, by and through Latah County, blah, 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 and submits the following. I'm just get goofy reading these. It submits the following initial response. All right, you guys, this is about the alibi. So we filed on April 17th. That's the one that became the butt of all the jokes with stargazing. This is in response. You guys are getting it here first. From everything I know, no one has talked about this information yet. So what are we going to learn? Let's see. What'll happen is you guys will probably see other people then, I don't know when, sometime this week, be like breaking news or whatever, but haha, they're late. At the outset, the state incorporates by reference as if fully set forth at this point, those portions of the state's, that sentence is not, okay, again, are you guys seeing what a difference, right? I can appreciate now, having just we read like 6 defense filings in a row. They were all very clear, right? And the sentences, like I'm reading this and I'm like, what the hell? At the outset, the state incorporates by reference as if fully set forth. At this point, those portions, this is confusing. So I appreciate, and if I were a judge, I would appreciate a well-constructed sentence that isn't confusing without any purpose. But to be fair, I can complain about Ann Taylor including those links with those really long articles and not being specific about what to look for. So fair to both sides, right? Critiquing both sides. As if I have any basis to do it in the first place. This is just my squirrel talk, All right. So some nonsense sentence here. I'm not going to read that again. Motion to compel notice of defensive alibi or alternatively to bar certain evidence to the extent that it relates to the adequacy and timeliness of the defendant's alibi notice. The state respectfully submits that the defendant's supplemental alibi response continues to lack, well, I think we can agree with this, to lack the specificity. All right, you guys, this is them saying it wasn't specific enough. This is important. Remember the whole stargazing thing? This is the response from the prosecution. This is a big deal. It lacks a specificity. Oh my God. Specificity. I promise I can read. My mouth is just getting tired. That's what she said. Required by Idaho Code 15519, which provides that the defense, quote, shall state the specific. Look, they underlined specific. They could have also, if they wanted to be fancy, they could have done it like in italics and like all caps. Place or places at which the defendant claims to have been. The whole point, let me just say this real quick. What's the point of the alibi defense? Now, if you were there on the most recent episode of the Murdoch trial, I didn't realize until Judge Newman brought it up in sentencing that they had filed an alibi defense for him. And I was like, holy shit, like BK, right? What is the purpose of, here's the purpose. What is the purpose? Let me just explain this. The purpose isn't so we can try to speculate as to where he was, just so everybody knows. Let's just make that clear. The purpose of this alibi defense isn't, it's not that. It's not so we can try to figure out, was he not there? Do they have the wrong person? No. The purpose is because if somebody was somewhere else, the prosecution needs to know where they were so they can then go seek the information and the witnesses involved in it. Point blank, period. That's the point. So it's like, oh, I was with Sarah Jane. I just made that name up. Well, the prosecution needs to know that so they can go figure out who Sarah Jane is and track her down. And, they can have it's discovery. It's discovery, right? Just like everything else. So that's the whole point. So with that in mind, it will make sense that what they're saying here is that the point is the defense should state the specific place or places the defendant claims to be. Oh, keep reading, Chelsea, because literally it says this. At the time of the alleged offense and the names and addresses right here. Bam. This was what I was saying. This is the point. I just didn't keep reading. Names and addresses of the witnesses upon, you guys, this is key. Let me read this again. Names and addresses of the witnesses upon whom he intends to rely to establish such alibi. Emphasis added right there. Can I highlight it? Let me read that again. This is the point. An alibi, it states the specific place or places, let me highlight it, the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. Again, so they can go check it out, right? Oh my God, stop doing that. Okay. I was talking to my computer. Sorry. The defendant's April 17th, 2020. So does that make sense? This isn't so we can speculate, right? This is practical reasons. And this is why I love the court filings, right? Because this is just giving us a whole different understanding as to what actually fucking matters and why things happen. And you wouldn't get this information without reading these. The defendant's April 17th, 2024 submission minimally adds to the, yeah, I agree with that. 100%. It was bullshit. The defendant states that he was driving around during the early morning hours. Yeah, it was complete and utter bullshit. And drove blah, blah, blah. Yeah, we all know. We've heard it. We've all heard about this, I'm sure. The why park thing. With the exception of the reference to, and I don't know how to say this, the why park, which is new. He's right. That's the only addition. I say he, assuming this is Bill Thompson. That's the only addition. The defendant is offering nothing new to his initial alibi, in quotes again. I love that because Judge also gave them some shade on this before too. That he was simply driving around during the morning hours, blah, blah. As the state noted during the August 2023 hearing, the state is aware that the defendant was driving. Yeah. Dude, that's sick. You guys see how sick it is that he's saying that? Let me read this again. You guys catch this? This is really good. This is intelligent snark right here. As the state noted during the August 2023 hearing, the state is aware that the defendant was driving around rural areas of these counties during the early morning hours. In fact, oh my God, it gets worse, you guys. This is awesome. In fact, the defendant's travels during that time. Like, in fact, so coincidentally, oh my God, I love this. The defendant's travels during that time happen to be, I added the happen to be, it says, are described in the original probable cause affidavit supporting the criminal complaint. Oh my God. So great. He's like, yeah, we know he was driving. How do we know? Oh, we put it in the PCA because it's how we know he did the murders. That's what he's saying. You guys, like, what is happening? Why is there a square? I don't know what's going on. Pardon the square. I got excited and I don't know, something happened. My mouse got excited as well and it made the square. You guys see how awesome that is? So as to this type of stuff, don't worry, my PowerPoint presentation is still to come. But well, we know his car was last seen driving at, I have it in my PowerPoint, like 4:03 a.m. or something. He passed the DoorDash dude. So I mean, I think he'd been in the house, but he wasn't waiting there that night because he was driving around. So, oh, Black Widow is such a sweetheart. She says, having no friends pulls on my heartstrings, but probably warranted. Yeah. Do you guys see how this is table DSN? I love it. I love you guys. Do you guys see how this is awesome though? They're like, how dare you come out and give us an alibi and say he was driving around? We know he was driving around because we're the ones that told you he was driving around because we saw him because it's in the PCA. Like, I freaking love it. So good. As to the defense, I don't know what this deals with the square. As the defense's reference to potential testimony about the location of the defendant's cell phone on the morning of November 13th, 2022, this information does not rise to the level of an alibi. Sure does not at the time of the homicides because the defendant's cell phone stopped reporting to the cellular network before the homicides and continued to not report until after the homicides. Now, we talked a lot about cell phone stuff with Murdaugh, and one thing that we talked about is airplane mode and all that. Now, here's what we learned. If a phone is on airplane mode, it could still potentially have some sort of communication to a tower. Now, part of that can depend on how many towers are around, right? So in both the cases with Murdaugh and in this case, they're in rural areas with very few towers. But from everything I learned, it was like if you're in a place with towers everywhere, like a big city, the potentiality of it pinging something, even on airplane mode, could still like happen. And furthermore, when I was researching this, they said the only way to make sure that your phone's not going to communicate with anything, period, point blank, 100%, you have to put it on airplane mode, turn it off, and take out the SIM card. So with all this research I was doing with Murdaugh, part of me wondered if potentially they could end up finding when his phone was either off or on airplane mode. I know it's been said it was on airplane mode, but you know what I haven't seen? Correct me if I'm wrong, I haven't seen that proven or cited in a court document. And like, for example, here it says stopped reporting. So in other words, I don't think the prosecution or any law enforcement or anything has said his phone was I don't think they've said his phone was on airplane mode or his phone was turned off because they are different. And I have always asked myself, which one was it, right? But everybody reporting on this, right, is saying it's on airplane mode, but I don't think we actually know. It could be off. He could have powered it off. Now, if it was on airplane mode and not powered off, there is the potential, this is what I'm saying the important thing is, there's a potential that it could actually still have given some information. And we wouldn't know that yet. Of course, we wouldn't know that till trial. But wouldn't that be crazy? And one thing we do know, remember guys, wifey, you were here, we talked about this, I remember. it would still record steps. Let's think back to Murdoch. When he first got to Moselle, he put his phone on airplane mode, but he didn't turn it off until 8:06, I think. And how do we know this? Because his phone wasn't doing any activity in terms of data or phone, but it was logging steps. We learned this. So if you put your phone in airplane mode, it's still going to log steps and it's still going to log orientation changes. Okay. So I remember getting really excited when we were talking about this because I thought to myself, if his phone was on airplane mode, if he had it in his pocket or something, you guys, what a treasure trove, right? Orientation changes, steps, right? Even if it was left in the car, that's still big. Again, it's still going to give you more data. Now, if it was powered off, nothing probably, right? So, but I don't think we actually know yet. Correct me if I'm wrong, but I don't think we know yet. So I'm curious. I'm really curious. I mean, you have to be not that smart. I mean, I will just say, like, if you're trying to do a crime, don't put it on airplane mode. Really, like, because if there's nothing what we've learned, among other things, is that there's still plenty a phone can do that could betray you in the end if it's on airplane mode. And if you're not intending to use it to communicate to anybody and you're not going to use it for the internet or whatever, why don't you just turn it off? If you don't want your fucking steps recorded or your whatever other shit. And or you could be smart and do what the experts say, which is put it on airplane mode, turn it off, and take out the SIM card. I don't know why you have to put it on airplane mode first before you do the other two things, but that's what it said in the article I read. So okay. But it'll be interesting. But are you guys seeing what I mean? Like, again, think about all of the people who talk about how his phone was on airplane mode. I just wanted to point out, for the record, I've not seen anything in a filing that states specifically the phone was on airplane mode. And here it says his cell phone stopped reporting, which could mean it was on airplane mode, or it could mean it was powered off, but they are not saying which. And I don't think we will know for sure until the trial. They're going to have an expert come in and talk about that. Like we saw in the Murdoch trial, that's going to be a whole thing. They can't just say it. So anytime you hear someone talk about his phone being on airplane mode, you should be annoyed, just saying, because you'd be like, we don't actually know that for sure. Really. It's speculation, and technically it qualifies as misinformation in my book because it's misinformation. All we know is his phone stopped reporting. So anyway, I need to be more diligent about reminding people of that. I think facts are important. That's just my personal opinion. Yes. So, right. So they're saying, of course, that alibi doesn't count, right? Because his phone was not reporting. The location of the defendant's cell phone at times other than the time of the homicides is not proof of or relevant to the defendant's specific location at the time of the homicides, right? It is the state's position that the defendant's continued failure to adequately comply with Idaho code things does not trigger a response under this other code. So what they're saying is it doesn't count as a alibi. If the court deems the defendant's supplemental response to be in compliance with the requirements of this code, that's the requirements that they're saying to submit an alibi. The state requests additional time pursuant to Idaho code. There's some numbers there to prepare a list of witnesses. Again, that's what they already said. The point is to establish a list of witnesses if they're saying there's an alibi. That's the point. As to witnesses to rebut a claim of an alibi, the defendant's failure to adequately comply with another code means the state does not know what specific assertions it needs to rebut. If the court allows the defense to offer further witnesses or information regarding the alibi, there's not going to have. I'm sorry. I'm going to go ahead and go on a limb here. I don't think there's going to be any witnesses that they can bring in. What do you guys think? Someone who's going to come in and be like, "Yeah, I was with him." I think that anyone that could do that is either deceased or is already a witness for the state because they were there living in the house. Personal opinion. And bring it into compliance with Idaho code, blah, blah. The state will then respond accordingly, etc. It has now been approximately 11 months since the state filed its request for discovery disclosure. Wow, it's been that long. You guys remember when they first asked for this alibi stuff? Almost a year. And almost a year and a half since the homicides occurred. The defendant has been given more time than he's legally entitled in order to provide his alibi. The state is substantially prejudiced and compromised in its ability to investigate and respond to new or additional alibi-related disclosures. Here's some case law. So what if we hear? So this is appeals, state appellate, Idaho Court of Appeals for here, from 2021. Okay, what do they say here? The state has a legitimate interest in obtaining timely and complete discovery response from the defendant. Okay, the state respectfully submits that we essentially remain in the same position. Yeah, and that like Juarez. So whenever they've already given a full case law, you always have to give the full thing. But if you're going to refer to it again, you can do an abbreviated version. So that's when it says like Juarez, they're referring to this citation. We don't know how this is an alibi at all. Nice. They quoted that. You guys, you see what they did here? They pulled up case law just so they could quote the. So what do I mean by this? Whoever said this would be a judge in the Idaho Court of Appeals, because that's what they're quoting. This is a case from the Court of Appeals in Idaho. And again, remember what I said. The best thing you can do is cite your authority, your case law from the Supreme Court, and then if not that, from the state, right? So in this situation, they put this case law here probably so they could quote it, and this would be a judge, and it's a quote, direct quote. Because what is case law? It's a judge's opinion, right? Just so you guys know. So this is a judge would have written this, and they said, quote, we don't know how this is an alibi at all. That's awesome. As the state further noted in its other motion to compel about the alibi and stuff, the United States Supreme Court has observed in Taylor v. Illinois, I feel like that's been mentioned several times, the ease with which an alibi can be fabricated, right? And the state's interest in protecting itself against an 11th hour. This is a good point. So this is the reasons why, right? The state's interest in protecting itself against an 11th hour defense is both obvious and legitimate. Yep, for sure. Based on the above, the state respectfully requests the court enter an order denying the defendant. So here's what they're saying. They're saying, all right, we gave you two shots. This is what's happening here. The prosecution is saying, we gave you 2 chances to give us an alibi. You didn't. Time's up. No more cookies for you. No soup for you. The defendant, they're saying they're requesting, but they can't make that choice, right? So all they can do is they can request the court. This is judge is the court. They're requesting that judge enter an order denying the defendant any further opportunity to do any more alibi nonsense. I think it's fair. I think they've had plenty of opportunity. I guarantee you the defense is going to fight back on this, though. It'll be interesting to see what they say. How are they going to back it up is the question, right? We'll see. I'm going to keep on top of these filings. But what are they going to say? How are they going to possibly ask for more time after this, right? It's almost embarrassing. Do you guys see what I'm saying? Like, do you agree? Like, I would be embarrassed in a way. Like, DSN. So, like, yeah. So I wonder what they're going to say. How are they going to ask for more time on this alibi? What do you guys think? I mean, can they interview the stars? The stars saw him looking at the stars. I mean, all right. Also as a runner, the way that they described all that bullshit about going running, I was like, no, that's accurate. It's just none of that is accurate. I can just say it's just none of that is how it would happen. All right. Guess what? We're on the last one, unless they've already done more. Oh my God. I hope not. All right. What do we have here? A notice of hearing. All right. So this is just like for everybody. We have a motion hearing on May the 2nd. Motion hearing and state's motion to close hearings. You guys, here it is. So this is going to be this is going to be the hearing we already mentioned about fighting over the May 14th hearing. Just like with the filings, it's the same with the hearings. There's a filing for a filing for filing, and then a hearing for a hearing for. So this is a hearing to talk about the hearing. Law is great. So on May 2nd, you guys, at 10 a.m., they're going to talk about, see, now I'm actually even more invested in these hearings. I mean, I was already invested. I already watched all of them, but now I'm like, fuck, like I want to really, what day is that? Maybe do you guys want me to stream it? Maybe I can stream it. We can watch it. Can we do that? I guess we can do that. Holy crap. Because like now I'm like, well, now I want to see where this goes, right? Because now this is the benefit, at least for me. Maybe you guys are like, this is just fun chatting with each other, and that's great. I love you guys, and I just hope you guys have fun. But for me, as I'm just being like so nerdy about this, I was already watching all the hearings and really, but I wasn't reading every single filing. I was just watching other people read them, right? But they don't read all of them. But by reading these now, having gone over it, I'm like even more excited for this hearing because now I already know what to be expecting and what the point is. And like, it's closing the loop, right? Like we've just gone through all of them arguing back and forth over this upcoming May 14th hearing, whether it should be closed or not. And this is going to be the hearing to discuss it. So what's going to happen? What can we expect? Well, the prosecution is going to elaborate on why they think Rule 32G supports that it should be closed. And then the defense is going to argue that it shouldn't be because they want it open. And again, just to remind everybody, I appreciated that so far in all these filings that we've read today, the defense wants everything open. They did not ask for anything to be closed or whatever. So I appreciate that. And let me see. Oh, can I open up a thing? Hold on. Let's just see. Maybe, I wonder if there's, oh, I don't have, hold on. Let me see if I can share this over here for you guys. I'm going to see, are you guys ready? I'm going to actually see if there's any more filings. Let me pull this over here for you guys to see. Hold on. Sliding it, screen sharing. This is what happens. Okay, let's see. So here's how we find out if there's more filings. It's possible, dude. It's possible. There it is. All right. So they're in chronological order. Look at all this. Are you guys watching? This is insane. Look, these are all, let's go back. Let's just appreciate this for a second. These are all of the filings in this case so far. How long will we scroll? Yeah, Black Witter says I call the moon to the stand. Hell yes, exactly. Glad you thought that was funny. All right, let's see. Okay, hold on. It's time for the Jeopardy music. Do 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 do. Wait, did I see Anjanette Levy? I did. Wow. I guess it goes again. I guess it modulates every time. Now at least we're in the right year. That's what we just read. That's the most recent filing. That's all the filings, guys. And look what we have here. Let's see how many filings are in here. Let's see. Is it as many? I bet it's not nearly as many. Because this Idaho, they've been filing shit like it's like there's no tomorrow. I mean, having said that, this case has been going on longer, right? Like with Chad Daybell, like it's an older case, but I think it's, look, we're already in 2024. I think it's less filings still, even though it's more time. Oh my God, look at that. This is the fun website. So one could spend, oh my God, it's going to take forever to scroll. One could spend a lifetime. Like if I really wanted to be an overachiever, I shouldn't say this because I'm going to have to do it. No, I'm not going to do it. I'm not going to be that crazy. I was going to say, like, to really overachieve this shit, it'd be like going back and reading all of these filings from day one, but that's not reasonable. I'm starting from here. I'm reading all the filings starting from here. That's going to be the goal. I think that's fine, right? So yeah, but nothing else additional yet. But you know what? There could be tomorrow. To quote, do you guys know that movie? What's it called? Rudolph the Red-Nosed Reindeer. And there's that little deer, Clarice. And she's the little deer that Rudolph is in love with. And she sings that song. There's always tomorrow for dreams to come true. What's the next lyric? Something. And then it says day. There's always tomorrow. I think it's then something else. Okay, for dreams to come true. And then it's like, tomorrow is not far away. Something like that. But every time for my whole life since being a kid, whenever I think about there's always tomorrow, literally, I sing that song either out loud or in my head. So that's what you guys have to face. You have to be subjected to that now. I apologize in advance, but I said, without thinking, I said there's always tomorrow, and then hence the song. But in other words, there could be a filing tomorrow. So I will keep up on that. But we also have tomorrow the Gloria Satterfield. So I think, hold on, I can't even believe we made it through all those filings. That is really impressive that we did it. So go us. You guys want to see my background on my computer? Hold on. Look, there he is. That's Frodo. That picture is from my apartment in Boone years ago. But look at him. Look at him. So usually, what's funny about his pictures, usually his ears are to the side like a fox, like a fennec fox, you know. But there was like this one day, and I just walked over, and that was just how he was sitting. I didn't try to make an like. I didn't say for him to look at the camera. Like I walked over, and that's what he was doing. Literally that pose, like that, with that face. And he wasn't moving, and he was just making that face. And he stayed like that for a while. I don't even know. He's so funny, right? And so then I like took the picture, and then I walked away, and then I came back, and he was still doing that. Oh my God, you guys, his baby pictures are too much. But it's funny because his ears are like straight up here. He looks kind of like a bunny rabbit, but usually he looks like a fox. But he's my piglet. So, okay, let me stop screen sharing. Hold on. How do I, okay, put my mouse. You put the mouse over here and then the mouse over there. Okay, there we go. So now that's just this. So I don't really know. I'll pull up our, whatchamacallit again here for anyone that didn't see it. Here we go. So this is, and the sparkles, I just learned I could do this with sparkles. So that's what I added to. But this should go through our little slideshow again here. Yeah. Because it's always good to have a reference too for geography's sake, right? Like where the hell is Idaho? Like, I don't know. There it is. Close to the Pacific Ocean. It's actually more like to the west than I maybe initially thought. So do you guys have any questions? I wasn't always able to look at the chat. I don't know if I missed anything that was like, especially like, I mean, everything's important, but if you guys had a question and I missed it, I apologize. And right, I know this is what I'm saying, right? Like it's insane. It's really, I pictured it more in the middle of the country than where it actually is. It's going to go through these pictures again. So, but yeah, if I missed a question, just if you wouldn't mind just retyping that, and I apologize. So there's this little sign, Heart of the Arts, it says. I didn't know it was artsy. That's a picture of it. Isn't it beautiful? I also did not think it had mountains like that. You guys also surprised? This is this painting from 1898 that this dude did of Moscow, Idaho. And look, there's that same mountain, you guys. Now that's interesting. So we don't often see this picture, but I think this picture is important. That's the back entrance there of the house. And then floors. Rest in peace, house. Yeah, Jessica, we're thinking the same thing. I also thought it was flat. We both thought it was flat and in the middle of the country. That's really funny. I wonder how did we both think that? It's interesting. Poor Idaho. Here's the kitchen. So really, the interior is really nice. You guys will see. I like that it had no carpeting. It was all flooring. I appreciate that. Look, there's no carpeting in any of these rooms. That looks like it's a living room or something. Bedroom. It's a big house. It actually doesn't look as big on the outside, but when you see the interior, I feel like it seems bigger. Another bedroomy thing on the bottom floor. Now, what's interesting, let me pause it. So I couldn't fit the whole picture, and I want you guys to take a look here. Because part of it got chopped off, but if you look at the very top of this picture on the ceiling, you can see something. There's a square there. And when I meant to look this up and I forgot when I was doing these pictures, but I was like, what the fuck is that? So this is on the top floor and there's a square thing there. And I'm like, is that an attic? And I meant to look it up and I forgot. Does anybody know? But you can probably find the original picture so you can see what I'm talking about. But there's like a square thing on the ceiling there. And I don't know what it is, but I want to know what it is, even if it's not relevant, because that's just how I am. All right, let's keep going. We'll go through these one more time. It's fun. I love looking at, pictures of things. And there we go. As I love, there's a lot of natural light. That's the other thing I really like about it. And it's very spacious looking. I just like it. Now here's an interesting one. Probably on the bottom floor, but we have like a washer and dryer and then a little sinky thing. No, I mean, not anymore. Used to be there, obviously. Sad days. So it's going to go through them again, but I want to also pause it on this picture of the old courthouse because I think it's cool. So Sparkle Squirrel, Squingwin. Yeah, so let's pause it here. Yeah, like, wow, you guys. I know me and Jessica are both like flabbergasted, but like it's close to the Pacific Ocean and it's mountains. Nuts. And there's Boise for reference too, which is nice. Yeah, I always pictured it on the other side of Montana, but from where it actually You know what's funny? I'm way better. I'm gonna pause it here while I say I am way better with world geography than I am US geography. And let me tell you guys, do you guys do the Wordle ever? Has anyone done the Wordle? I have a thing that I do every day. Well, it's 3 things. Every day I do the Wordle and I do the Worldle and I do the Loodle. And I'll put the last 2 in the chat in case you're curious. The Worldle is this. It's like Wordle, but for world. It's country. So this is the reason when I say I'm better at world geography than I am state geography or US geography. The Worldle gives you a country and it's just in black and white and it's like the shape of it, right? The outline, like the shape of it. And then you have like 6 guesses, just like in the Wordle, you have 6 guesses to guess the country. And what it does is like, let's say you guess, I don't know, what's the country? Lebanon. Okay. Wherever you guess, it's going to put a, oh, that's awesome that your son it's not a game, but does Wordle. It gives you an arrow up, down, left, right, or like in the corners, right? So like northeast, whatever. It points and then it gives you a percentage of how close you are. And you have 6 tries to get it. But like I've been doing it for so long that like I pretty much get every country in one guess for the most part now because you really learn like I guess it kind of is geography because you do learn where things are in reference because of the arrows, but like you recognize the country shape for sure. And then the Loodle, I'll spell that in the chat, is this one. This is, you have to do an app for it, but it's free. But it's like Wordle, but it's only naughty words. And sometimes they do 5-letter words and sometimes they do 6-letter words, but they also have a function on there where you can get a hint of a letter. But other than that, it's just like the same premise as Wordle. So I always do those 3. I just love it. And the Loodle uses words that are across the globe. Like some of them are like words that are used maybe in other cultures and stuff, but but yeah, so, okay, but let me keep playing. I was going to go and show you guys this courthouse real quick here. The Ada County courthouse is much nicer. And there's that same courtroom we always see where they have all their hearings. They're going to be having that hearing on May 2nd. So so yeah, you guys want me to cover that? It's in 2 days, right? Or something. 3 days. It's on May 2nd. What is that, Thursday? It's on May 2nd. All right, so here's Latah County's first courthouse built in 1888. This is actually the same year as the painting that we're going to see here in just a second. Look at that, though. All right, so this is the same year, I'm pretty sure, as, we'll get to it in just a second. Or wait, no, the painting was 10 years after, but still, only a decade later. I think it's the next picture. I don't know, it's after this. Oh, yeah. Again, look at those mountains, though. It's beautiful, right? That one. All right. I just fast forwarded it. This picture or painting was done 10 years after the courthouse was built. Look at all the things we've learned. And what's this in the bottom corner, left corner? I don't even know. Is that the university? I don't know what that is. That's a beautiful structure. It's got it like special. You guys see what I mean in the corner? What is that? special building. I have no idea. I have to know what that is. I need to make a note to self to look up that and look up this thing in the ceiling. This is my life. Squirrel holes. Okay, that's all I have though, because there's no more filings. So, y'all, tomorrow we will have Gloria Satterfield, and there's a lot of it's a lot of court filings, and the court filings are super dramatic and spicy. But we're gonna start with like the 911 call. I've got a whole big plan for it. We're gonna go in chronological order from when things happened. We're going to talk about insurance and how that works. We're going to develop a much greater understanding of that, because that's going to be important to understanding what was going on, all the fuckery. And we are going to together compile all of the inconsistencies. Jessica said, I love that you made a channel. I don't mean to disappoint you when I say this, but I've had a YouTube channel since high school, because back then it was before Google owned it. And like, you couldn't be on YouTube if you didn't have like a channel, like, but I made it to put all my violin videos. Like that was the point, to store all my violin videos. Like everyone that was a music major had one, you know what I mean? Like it was so that people that weren't able to make it to your recital could watch all your videos. So I've had it since I was in high school. And like, of course, now you don't have to have a channel to have a YouTube account, but it used to be that like, before it was Google affiliated, like the only people that had, like, you didn't have to use to sign in and stuff, right? So there was none of that. So if you had a YouTube account and channel were the same thing, right? If that makes any type of sense. So I've had it forever. But yeah, I'm glad too. I'm so happy you're here. That's awesome. And yeah, it's really funny. It's just it's a funny concept because YouTube was so different the way it was back then. Like, and I remember when it got bought by Google and it was like a big deal. And then it was like, whoa, you know, but like, but it was like, you know, just a way, for me, it was like a way to store all my violin videos without taking up space on my computer for the most part. And then, you know, sharing them with people that wanted to see them. But yeah, I mean, I just started doing like law related stuff just by happenstance. Like, I don't even know when, but it started with Be Heard. But we did the whole Murdoch trial, gavel to gavel. And now we're starting the Gloria Satterfield series. So, but it's fun. I love we have a lot of fun on these live streams. As you can see, it's a great group. And yeah, it's just full of craziness. And, you know, yeah. So we have a squirrely time. But yeah, I'm happy that you're here, and hopefully you'll be able to join us tomorrow for the Gloria Satterfield coverage as that starts. Of course, better late than never, 100%. Yeah. And we already have our new song. Where did you come from? Where did you go? Where did you come from? Good night, Joe. Yep. Both my orchids, for anyone who's wondering, not that anyone is wondering, but I'm just going to say both my orchids are still alive. So that's good. Oh, and Jessica also, in case you didn't know, let me do this. There's the Discord as well. And on the Discord, we all have a really good time, you know, and I have no rule. By the way, I guess I have no rules. So like cursing's fine, anything. I have no rules. So like, I know we're all used to having certain rules on YouTube that most channels will have, but I don't have any rules. So no rules, like the Wild West, but it's the same on the Discord. So, but it's great. We just have, you know, our ongoing chat, and then, you know, it's like STS obviously, but much smaller. And there's also some people that aren't STS that you will probably get to know that are here oftentimes on the live streams. But the thing is that I have it set up so that it will give notifications too for live streams and videos and stuff, because as everyone knows, YouTube, sometimes they don't go through. But everybody has said that they always get the notifications through Discord. Awesome. That's awesome. Glad you're there. So yeah, everyone says that those always go through. And I can say on my end, it's the same thing. Like, I don't always get notifications for SDS on YouTube, but I always get them on the Discord. But there's also going to be, I've got a tab on there. So since I know you're not, since you just joined, like, I'm going to do Chad in the same way as Murdoch, which is gavel to gavel, but with all of the full context and backstory. So like the way that I did it with Murdoch was like when it came to a certain witness or a certain thing came up, if there was like about, you know, other context or backs, like we would go through and like pull up whether it was whatever thing it was. So like, I don't know, if you're curious what I mean, you could go and check out one of the videos because it's kind of hard to explain. But it was like a full understanding. And each episode there was like I did a presentation breaking down some sort of topic. But you can see, and all of them have timestamps. So I timestamp anytime there's like a topic change, including a tangent, because there's always going to be tangents. But all of them have timestamps, and yeah, it's all of it's in chronological order, again, gavel to gavel, except I take out like, you know, if it's really redundant or if it's like silence or whatever, right? So you do end up saving a lot of time, you know, of course, versus watching it at the time. But anyway, but I'm going to be doing that with Chad, but I'm waiting for the trial to end so that people aren't watching the current day of the trial and previous days of the trial at the same time. That wouldn't make any fucking sense. So what'll happen is in the meantime, I'm going to do the Gloria Satterfield series. BK, if I'm doing the BK documents, that'll obviously be ongoing, but the Gloria Satterfield series, and then hopefully that'll work out to where then Chad's trial's over. Maybe by then someone will have figured out how to like, you know, make the audio better and shit too. Because right now it is a little bit hard. And then we'll be doing it's like a trial, gavel to gavel trial / like deep dive. Like in Murdoch, it was awesome. We went into like all the railroad history and stuff too, and it was great. But anyway, but that'll be coming up as well. So, but thanks everybody for being here, and I had a lot of fun. Hopefully you guys learned something, and I will see y'all tomorrow for Gloria Satterfield. And I will roll the outro. See you guys hopefully tomorrow.